Welcome back. So we've given some background now on contracts and contracting systems, and now we'll go into contracts in more detail. So what we're going to do is we're going to break down contracts into three component parts. We're going to look at, first of all, the formation of contracts for the international sale of goods. We'll look at performance of contracts. How do we know when some party is performed or not? And then we'll look at damages and defenses to contractual claims. So breaking it down to formation, performance, and defenses. Now, we return back to this idea of what is a contract. And a contract essentially is a legally enforceable promise, or a set of legally enforceable promises. Now, the law will only enforce certain types of promises. Only certain promises will the law enforce. And we talk a lot about enforceability, but what does enforceability mean? Well, enforceability means that a private party can call upon the power of the state, can call upon the authority of the state to intervene into a private promise. And the state can force one of those parties to keep their promise under the contract. So it's kind of a radical idea when you think about it, when you think that what we're doing when we sue someone for breach of contract is saying, look, he and I had a deal, and now we're going to call upon you, the state of Texas or the state of Oklahoma or wherever, and we're going to have you come in and enforce this promise. And if the other side still refuses to perform, then now I can call upon the sheriff to come in and take his things and sell them at a public auction and give the money to me. So when we talk about enforcing contracts, what we're really talking about is invoking the power of the state to intervene in a very private matter, a private personal matter. So therefore, we want to be very reluctant as to say that the law is going to enforce every promise, because we only want to call upon the power of the state for certain types of promises. So in order to determine enforceability, we have to start with the notion of, do we have an enforceable promise? And we determine that by knowing, was this contract valid when formed? So we're going to talk about some contract formation issues, and there's a number of them, and you probably will remember some of these from your introductory legal studies course. If you've taken commercial transactions and you've studied the UCC, then you'll have some more of these issues in mind. But we'll start with those, and we'll talk about what the law is under the CISG, and we can compare and contrast that to the common law or to the UCC. Remember, we have these three different contracting systems at play. Let's start off with the question of a writing. Is a writing necessary for a contract? Well, in the U.S., we have a doctrine called the Statute of Frauds. And what the Statute of Fraud says is that some contracts must be in writing in order to be enforceable. Not all contracts, but some contracts must be in writing. Now, what are those contracts? Well, essentially, the reason we call this the Statute of Frauds is these are the kinds of contracts that would be subject to fraudulent behavior if there wasn't a writing. And number one on those is real property. Remember, real property is land or anything attached to the land. If we were to permit oral contracts for the sale of real property, then we could have two parties enter into an agreement to sell a piece of land from one party to the other. And then both parties could live out their life, they could die, and their heirs would come into the scene. And one can imagine that there might be a dispute over who owns the property when there is no writing. So any contract that has to do with real property must be in writing. What other contracts are there? Well, a contract that cannot be executed within a year of its formation must be in writing. Again, think of it from a fraudulent standpoint. If it's a long-term contract, people's memories get faded. People forget what it is they agreed to or what they promised. So if the contract cannot be performed within a year of execution of the contract, then it must be in writing. The contract to pay the debt of someone else is another example of a contract that has to be in writing. If you guarantee a repayment of a debt for a friend of yours, that guarantee must be in writing in order for it to be valid. And finally, any contract having to do with contemplation of marriage has to be in writing. Obviously, the best example of this is a prenuptial agreement. Prenuptial agreements have to be in writing. So that's according to the common law. Those are 5 restrictions on oral contracts in the common law. Now, in the common law, most contracts do not have to be in writing. The only exceptions are those that we just discussed, Now, the UCC also has a writing requirement. What the UCC says is any contract for the sale of goods in excess of $500 must be in writing. Now, at the time the UCC was drafted, $500 was a rather significant sum. And so what the drafters of the UCC believed was we should make any large transaction must be in writing. And large was defined as $500. Now, of course, $500 today is not what $500 was back in the 1950s when the UCC went into effect in most states. So one could argue that the $500 figure is outdated. And in fact, there was an attempt to amend the UCC a few years ago, I would say probably 10 or so years ago, to raise that dollar level to $5,000, which would more accurately reflect the notion of important contract, $5,000 or above. And nevertheless, this movement did not succeed, and therefore that $500 figure is still with us. So any contract for the sale of goods within the United States in excess of $500 has to be in writing. So finally, we turn to the CISG. What does the CISG say about writing? Well, under CISG Article 11, a contract for the international sale of goods does not have to be in writing. Must not be concluded in writing. So from a CISG perspective, there is no writing requirement. No writing requirement. How do we prove this up in a court of law? How do we prove up what the details of a contract are? Well, we ask the parties themselves can testify, and any other witness as to the contract could also testify. It's kind of unusual that in a long-distance contractual relation that no writing is required, but that is the law. That is the law. No writing required under the CISG. Now, this idea of writing raises another issue, and that would be what's called the parole evidence rule. Now, one of the reasons that we have a writing requirement in the U.S. is the idea that we want to have the terms of the contract reduced to writing so that we understand what those terms are. So we know what the terms of the contract are in order to determine whether performance has occurred or to determine the proper measure of damages. Now, under the common law says that if there is a writing, then a court cannot consider any evidence outside of the writing. As long as the writing is unambiguous and straightforward, a court cannot consider any evidence outside of what the writing says. Meaning, if the parties to the contract want to testify as to what was in their heads when they signed the contract, they cannot do so. The court can only look at the contract, at the writing, We also hear the parole evidence rule referred to as the extrinsic evidence rule. And what it says is we can't look at any evidence, any extrinsic evidence, outside of the writing. So where there's a writing, they can only look to the writing. Now, and the same holds true for the UCC. You cannot consider any evidence outside of the writing. Under the CISG, that is not true. So there could be a writing, there could be a written contract between parties for the international sale of goods. Nevertheless, if there is no, if a dispute arises, the parties will be able to testify as to what was in their heads or what they believed. Furthermore, any other witness could also testify as to the terms of the agreement. Under the CISG, the writing is not the only evidence, it's just one more form of evidence. Under the CISG, a court can consider all the relevant circumstances of a case, including negotiations, including any practices that occurred during the performance of the contract, any subsequent conduct of the parties, any past dealings between the parties. A court can consider all of those in determining what is the meaning of a contract. Now, the final thing we want to talk about in terms of understanding a contract is known as trade usage. And if in the United States, if there is a gap in the contract, if the contract itself, the writing is ambiguous as to a certain term, to fill those gaps, the court can look at any standard usage in the trade. What do people in the trade mean when they use these terms? So trade usages can provide guidance for courts in determining what is the meaning of a contract. Now, this trade usage is also permitted under the CISG. The widespread customs of an industry or the practice of merchants in their past dealings, whatever the language of the merchants is, that can be used to interpret a contract under the CISG.